5 seconds. Start. The challenge in this criminal appeal is to the judgment and the order dated 20th August 2024 passed by the High Court of Chhattisgarh at Bilaspur. By the impugned order, which was passed on a petition under Section 482 Code of Criminal Procedure 1973, the High Court quashed proceedings arising out of a first information report dated 29th November 2016 bearing number 608 of 2016, registered at Police Station Mohannagar, lodged by the first appellant against the second to fourth respondent for offences under Section 3 and 4 of the Dowry Prohibition Act 1961. While the second appellant is the daughter of the first appellant and second, third and fourth respondents are the father, mother and brother respectively of the fifth respondent. It is not in dispute that the first appellant and the second respondent had engaged in negotiations for solemnization of marriage between the second appellant and the fifth respondent. However, such negotiations did not lead to the marriage. It was alleged in the FIR that the negotiation failed because of the inability of the first appellant to meet the continuous demands for dowry raised by the second respondent and the co-accused. Division Bench of the High Court record in paragraph 13 of the impugned order that the allegations contained in the FIR, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute an offence under Section 3 and 4 of the 1961 Act against the first to third petitioners before it, second, third and fourth respondent herein, as the allegations are vague and omnibus in nature and no specific allegations are made against them. However, the allegations levelled against the fifth respondent did not warrant quashing of the FIR insofar as he is concerned. Accordingly, in exercise of inherent powers, the FIR was quashed quo the second, third and fourth respondent, while it was sustained quo the fifth respondent. We have heard learned counsel appearing for the parties and persuade the impugned order together with the FIR to ascertain as to whether the allegation levelled by the first appellant in the FIR did disclose any offence alleged to have been committed by the second, third and fourth respondents under the 1961 Act, and also as to whether the High Court was justified in returning the findings it did. Having read the FIR as it is, we do find specific and definite allegations with particulars of dates and time being disclosed, which prima facie contain ingredients of offences alleged committed by the second, third and fourth respondents punishable under the relevant law. In fact, on a bare reading of the FIR, we are left to wonder what more was required of the first appellant to allege that could, in the view of the High Court, constitute full and fair disclosure of offences. In view thereof, we are at a total loss to comprehend as to how the FIR and the consequent proceedings against the second, third and fourth respondents could have been quashed by the High Court, holding that the allegations against them are vague and omnibus in nature. Learned senior counsel appearing for the second, third and fourth respondents did not seek to justify the impugned order relying on the ground assigned by the High Court. Instead, he sought to contend that the first appellant had made a misrepresentation to the second respondent about the former status. Our attention is drawn to page 19 of the counter affidavit of Buttress, the contention regarding misrepresentation. Also, the decision of this court in the state of Haryana versus Bhajanlal is cited and clause 7 of paragraph 102 thereof relied on the contended that the criminal proceedings having been manifestly attended with malafide and instituted with an ulterior motive for wreaking vengeance, the High Court was justified in quashing the criminal proceedings. We are in respectful disagreement with the aforesaid contention for twin reasons. First, whether or not there has been misrepresentation is entirely a question of fact which cannot be decided at the stage when the inherent power of the High Court are invoked for quashing of an FIR criminal proceedings. Such a question obviously has to be left for a decision at the trial if at all a defense to that effect is raised, and it would then be for the trial court to consider the same while it returns its findings on the question of guilt or otherwise. Secondly, the expression manifestly attended with malafide the following criminal proceedings as appearing in clause 7 of paragraph 102 of Bhajanlal Supra makes the position clear that malafide must be manifest on the face of the FIR. The present case does not fall in that category. Bhajanlal Supra therefore does not aid the second, third and fourth respondents. Even otherwise, the FIR and the consequent proceedings were not quashed by the High Court on the ground that the same were manifestly attended with malafide or that the proceedings were maliciously instituted with an ulterior motive for wreaking vengeance. Full stop.